portion.
We're recording this for Julian.
Paula of today. So again, just to reiterate my background, I'm Arthur Katz. I've worked for about 6 years at a private law firm doing commercial leasing, primarily for commercial landlords of various different sizes. We've represented all kinds of landlords, down from really small family-owned businesses all the way on up to triple net tenants in kind of anchor mall type settings, all including some of the Chipotle's and Taco Bells that we're going to find ourselves up against in a lot of these communities right now. So what I'm hoping to bring to the table today is a perspective from the other side as to what landlords and landlords attorneys' points of view are, some negotiating points that we can talk about together and as a team throughout the term of the project, of the contract. And I've represented a fair number of tenants as well, so I think that I'll try to give you kind of a well-rounded experience today of the kinds of things that you'll see on both sides. So just to get us all up to speed, I wanted to see if Missy could introduce yourself real quick to the group and get a little bit of background on you.
Sure. Hi everybody, sorry it's late. I'm Missy. I'm also from the Community Development Project at the Urban Justice Center. I'm an attorney in both our capacity building practice and our equitable neighborhoods practice. Relevant experiences?
Yeah.
So we work with a lot of nonprofits. So I've done more nonprofit leases than for-profit, but we also work with a lot of worker co-ops. And so I've negotiated a couple commercial leases for those businesses.
Excellent. So I'm glad you went through that. That was a big part of my agenda, was to do some personal intros and to get a sense of everybody's background and where everybody's starting off. And what I kind of want to get everybody into the habit of thinking about is commercial leasing is not really a standalone practice of law. For me, it's something that borrows from almost every single other practice of law that you all are bringing to the table right now. So, for example, rezoning is something that's going to be important in the permitted use and laws, rules, and regulations provisions when you're drafting them. Working with nonprofits, a nonprofit lease is still a lease. It's a contract. Any contract work that you've done, commercial lease is just a contract. Any litigation that you've done, you have a sense of what things look like and how costs quickly spiral out of control whenever there's any kind of litigation or even a threat of litigation. It's very helpful to know in drafting. Residential leases and residential housing has some really important transferable skills. So I really want to stress that from my perspective, from going around the room, nobody here is starting from scratch. This is like really kind of this is a collaborative environment, and this is the kind of subject area that any of your skills is going to be useful in understanding the work that we're going to be doing. So then I'm going to go through, and I'm sorry I'm going to be walking back and forth, but commercial lease is kind of in chat. So I'm going to go through a little bit of the commercial leasing landscape and our role. We'll talk about the methods and the goals for this training. Kelsey's going to talk a little bit about some issues in counseling small businesses of the type that are going to be eligible, qualify for our program. And we'll talk about some representative scenarios for the CLA program and what kind of documents the clients are going to be bringing to you in various different circumstances when we do find them eligible. And then from there, we'll go through a substantive training through the revenue lease form that I've passed out to everybody. The break's going to be a little bit different. Generally, I'm going to try to, when I get to the lease portion, I'm going to go through the lease provisions one by one. And then, given timing, I'd like to hold all questions until the end of the portion before we break, and till the end before we break for the day. In part because of timing issues, and also in part because a lot of the provisions are correlated. And so if you have a question about something in the beginning, it's very likely that we can address it in a better sense after we talk about another provision at the end of the presentation. And in the meantime, if you have any super urgent pressing questions, feel free to let me know. We can kind of park them here on the board and get to them as they're necessary. And then at the end, I want to take a little bit of time to talk about final thoughts and resources that we can share as a group, and maybe some strategies for making our monthly meetings as effective as possible from a substantive standpoint, in order to establish some best practices for our clients. All right. So what is going on currently in commercial leasing? Take what I'm telling you with a grain of salt, because this program is kind of changing the landscape a bit, and in a good way, I hope. But we're really kind of shaking things up. Oh, and I want to say that the version of the presentation that you have in front of you is kind of the short form version. It's not really wordy. I'm going to talk a little bit more than just what's on the screen. But I have kind of my more detailed presenter version that I'm going to post onto Box after today for everybody to see, both of the versions. So traditionally, commercial leasing has been very landlord driven. So New York City in particular is a caveat emptor jurisdiction, and the landlord and real estate lobby has really controlled most facets of the giving of commercial and negotiating of commercial leases for a very long time. The predominant lease forms that you're going to see are the revenue lease form that you see in front of you, the ridiculously antiquated and outdated legal-sized form that was drafted, I think, sometime in the 70s by the Real Estate Board in New York, together with the help of the real estate lobby and the landlord lobby. It's incredibly landlord-friendly.
And usually reproduced 50 times in blurry.
Yes.
And you're like, okay, so this is what we got to mark up.
Traditionally, you have to buy this form, and landlords will buy one and then just keep photocopying it in various forms throughout the decades. And this is just a starting point. This is just an easy starting point that landlords use. They will typically, for a new lease, they'll add their own rider. There'll be some minor edits here and there on the form lease, but really they just use this as a kind of a baseline. Same thing with the city bar lease form. I think it's still very landlord friendly. It's just laid out in a better way. It's actually, text searchable, and you can manipulate the text, and it's more visually pleasing. So you may see that one as well, and I'll post that on Box so you can see what it looks like. It covers a lot of the same issues, and typically with that form, instead of a separate landlord rider, they'll just be able to add additional paragraphs into that lease form for the initial set of negotiations with you as a tenant. Just to get a perspective, I wanted to talk about kind of where we are in the landscape. So in the residential side, we've got universal access to legal representation now in landlord-tenant court, which is huge, and that's already having repercussions in lowering the rates of frivolous lawsuits and kind of normalizing the kinds of summary proceedings, the kinds of numbers of summary proceedings that we're seeing in civil courts throughout the city. And we're also having, push for affordable housing from some key actors. In the commercial side, we've been a little bit more slow to catch up. And so we have last year, thanks to some people in this room and USB NYC, we have the anti-harassment law, which went into effect. As of last week, I still haven't seen any kind of movement as far as testing it in the courts. I don't know of anybody that's actually filed a lawsuit. There's no Shepherd site for it yet. But that's one of the things that we're going to be closely monitoring in conjunction with this program, I think, especially since landlord harassment is one of the issues that we can, one of the legal service matters that we can assist with. And of course the CLA program. And so I consider us really at the forefront as kind of a catalyst for change in the landlord-tenant community on the commercial side, which has been really kind of frozen in time. As you can see from the lease form, it's been frozen in time for quite a long time. And I'm getting some, through the grapevine, I'm getting some senses from my previous contacts in private practice, especially on the landlord side, that the landlords are taking notice that tenants are not just going to sit by. More and more tenants are going to be represented in the negotiation stage or in the renewal stage. And so a lot of the things that may not have been up for grabs or up for negotiation in the past maybe on the table now. And so everything that we're going to talk about today may be evolving. Just keep that in mind. If we talk about something today that I would think may never ever be up for negotiation with the typical landlord, we may find that that would change given the current landscape, and that would be great. So that's something that we can talk about at our monthly meetings and figure out kind of trends and best practices for addressing certain types of provisions in the lease. So really basic slide. What is and what isn't a commercial lease? This is something that a lot of clients may not understand really as well, and so I think it's a good place to start. So a commercial lease is really just a contractual agreement to occupy a commercial space. What that means is that it does not have a lot of the protections that a residential lease has under the law. There's no regulated protections for the tenant. For example, the landlord is not required to provide repairs or heat, or there's no warranty of habitability. None of that stuff exists unless it's actually negotiated in the lease, within the four corners of the commercial lease. There's no legal restriction on the rent that the landlord may charge for initial or renewals terms. There's no commercial rent control or rent regulation. There's no legal requirement that a landlord renew a lease unless there is an option explicitly spelled out in the commercial lease. There's no assistance or right to counsel necessarily, although now the CLA program is changing that a little bit, except for once we get to litigation stage, any business in a corporate form has to be represented by an attorney. There's no statutory reciprocal attorney's fees requirement, which in my opinion really opens the door to a lot of frivolous lawsuits, a lot of bullying, a lot of harassment on the landlord side, because they feel that if they can prevail in any sense of the word, either in litigation or in non-litigation, then they, under the terms of the lease, will be entitled to attorney's fees. And there's nothing reciprocal about that necessarily in the form lease, where if the tenant wins, then they get their attorney's fees back. It's very lopsided. In my experience, landlords have been very against playing with that provision. I think that's something that we could work on and see if we can get a little bit fairer. It's very unfair. In the residential context, for example, there's, I think it's RPL 234, which says that, statutory text, which actually says that if you have this kind of provision in a commercial lease that says that only the landlord is entitled to attorney's fees if they are the prevailing party in a certain dispute, then that provision is deemed to be reciprocal. And so the tenant is also entitled to attorney's fees if they prevail in a defense or in their own action against the landlord. So maybe that's something that we can, as a group, be mindful of as a way to kind of even out the landscape as we move along. And then finally, there's no duty for the landlord to mitigate damages. And that's something that we'll get to later on that at Balls we've sort of targeted as possibly something that we can work on in a bigger picture, maybe with the NYC or otherwise on a policy basis. It works a little bit in conjunction with the warehousing epidemic that we're seeing in commercial spaces, where landlords are taking vacant space and just keeping it vacant, just parking it and waiting for rents to go up or the area to gentrify or to change, and that's having a negative effect on, well, in every other way for our potential clients. And so part of that is the fact that under New York State case law, a landlord is explicitly allowed to sit back, do nothing, and collect rent for the remainder of the lease term if the tenant has been evicted or has left or abandoned the premises. So I think that's a big hole that we can all kind of take a look at together and keep in mind as we go through in our presentation. This training, I kind of went back and forth about how to do it. I think that what I want to get across is that I want everybody to be able to identify key commercial leasing issues and the provisions going through the provisions of the REVNY form. As much as I hate the REVNY form, as much as I hate what it stands for and its genesis, I think that it's really useful for pinpointing 90 to 95% of all the different kinds of provisions that you're going to see either in a lease form or in a rider. And so I just think it's a nice, neat-ish way to go through and present all of these various topics. I'm not necessarily endorsing the form, but you're going to see a lot of it, so you might as well get familiar with it. And so I also want to explain the key language jumping off of the lease form, also thinking about corollary language that you'll see in a landlord's rider, and then from there jumping off to the different kind of language that you can use to mitigate anything that you find there to benefit your client. Goals for this training. I'd like to provide an overview, just an overview of commercial leasing. This is quite a small crash course to give you a baseline for understanding the key provisions in a commercial lease, to give you examples of the competing interests between landlords and tenants on negotiating specific points in a commercial lease, to provide the relative persuasiveness or effectiveness of advocacy on a particular issue and on a holistic basis. So that's kind of what we talked about. All of these new things may be unlocked and up for grabs from a negotiating standpoint just by the very fact that there is a CLE program and now landlords are on notice that tenants, small commercial tenants especially, are going to have legal representation in disputes and at the new and renewal lease stages. I also want to identify as a group some issues of particular interest or complexity that we can ask an expert or facilitator to come in and talk to us as a group at some of our monthly meetings. So we're thinking about maybe as part of the check-ins every month to have kind of a brown bag where we invite an expert to talk about a specific issue about commercial leasing or ancillary related issue from an expert standpoint. So we have a preliminary list of things that we'd like to see. If anybody else, if something clicks, throughout the presentation today or at any time, let me know. We'll keep that as a running tab. And finally, I want to talk about formulating an inter-organizational channel for sharing best practices, for hosting these expert presentations, and for, to the extent that we need them, creating draft provisions, draft model language as kind of a living document based upon the kinds of issues and outcomes that we see in our organizations. So I want to turn it over real quick to Kelsey, who's going to talk a little bit about the process of counseling a new business owner and some considerations to make there.
Sure.
All right.
I did not have time to make a slide, so that I apologize. And I'm going to be very brief about this. So I just wanted to bring up a few things that are relevant to counseling small businesses in particular and to keep in mind and kind of go over what the process looks like for them before they get to you, just so you kind of know how what they've already gone through and how that should affect your counseling. One thing I do want to note that is helpful is the commercial lease guide that we sent around beforehand. So Balls did this with the city last year. We had a contract with them, and among other things, we drafted this commercial lease guide, some help with pro bono counsel. And this is directed towards the tenants themselves, right? So it's not an attorney guide, it's really meant for the small businesses. But, and we're gonna go over, the bulk of it really was these things we're gonna go over when we go through the revenue lease. But the few beginning pages I think are very helpful. And identify some additional resources. Do people get a chance to kind of look over this and briefly, at least maybe some people know? Okay, so I'm just going to tell you a little bit about it. First, there's a little bit of an explanation about who the different people are that are involved in a commercial lease. So it's not just the tenant, it's not just the attorney, talking about brokers, architects, contractors, engineers that might have to all be involved before the actual execution of the lease. So I would just take a look at it. I want to point out, in particular, the real estate broker. So we're all a little bit familiar with that because of residential leases. It's similar in commercial leasing in that the broker is paid by the landlord. But you can also purchase the services of a tenant representative so that they can be advising you on your best interests rather than relying on a landlord's broker who's obviously incentivized to close the deal as quickly as possible and for an amount of money that will benefit them directly. So because we're working with small businesses that are by definition low and moderate income, they may not have the resources to engage the services of tenant representative, and so they're relying on the assistance of a broker's landlord or a landlord's broker. So just want to go into it with that. in mind. So some of your clients might be sophisticated. This might be, especially for the new lease, especially for some, this might not be their first commercial lease. They might be familiar with the process, but for many others, this might be the first time that they've gone through this. And before we get them into a lease and really and commit them to paying a lot of money for a long period of time, we want to make sure that they've thought through some of these essential questions about whether this space is going to actually work for them. And this is pretty, I think this is very much common sense, and this applies to the way we counsel clients on any legal issues. We want to make sure we get to know the clients and what their needs are before we actually have them commit to signing something. So that's the first few pages of this guide to talk about questions you could ask the clients, make sure that they've thought about certain things like what they need out of the space, like access issues. There's things like deliveries, what kind of traffic are you going to be having in front of your store? Is that going to be sufficient for your business? Now, we can't necessarily answer those questions for the client, right, because we're not business counselors, but just making sure that they've thought about it and directing them to other resources that might be available to them. So, there's merchant associations they could get involved with. Some of the business improvement districts have staff that can advise them. Small business development centers can advise them if they need business plans and things like that. You might want to do kind of that initial check-in with them to make sure that they understand that they've done some of this kind of planning already before you actually commit them to a very expensive and long lease. So again, kind of common sense, and I would just refer people back to the guide for some specific questions to go through. The other thing I just wanted to mention, and maybe Arthur's going to go over this too, but because we're dealing with small businesses, very small businesses, I think, which is not necessarily the kind of SBA definition of small business, but more like we call our project the micro enterprise businesses. We're talking about very small ones. So they're going to be looking for very small spaces, which means that they're not going to have as much negotiating power because the smaller the space, the less the landlord wants to negotiate. It's not as they don't have the financial incentive to give tenants what they want. So just keep that in mind. So that means you're going to have to really work with the client to prioritize what their needs are and be able to really fight for the things that are really important to them, because you're probably going to have to give in on a lot of other things. It's also, your bargaining power is going to be dependent on the motivation of the landlord, so how long the space has been vacant, and then the general market conditions in that area. So the location of the property, the vacancy rate in the surrounding buildings. Now that information is sometimes hard for us to get as attorneys. So we might be asking, we're kind of looking into ways that we might be able to add a component of that component to this program, because we're not real estate brokers and we don't know what the vacancy rate is in the surrounding buildings, and that's something we really get from the brokers. So we want to just, we might be able to get that from the landlord's broker, the tenant representative if they have one, and we're looking at ways to establish relationships with professionals that could be able to provide that background for us, that we have some knowledge going into the negotiation of what our negotiation power is with the landlord. I think that's all I wanted to mention in that part.
Yeah.
Does that sound good?
Yeah,
Okay.
great. And I think two of the things that you mentioned are on the list, or going on the list of kind of expert areas that we may want to expand upon or bring in a facilitator in our monthly meetings, which is market conditions, somebody from the broker's side, to give us a better sense of what's reasonable and what's not reasonable, what's going on in the market in any particular neighborhood. And then another thing is, I thought it would be helpful to have somebody come in and talk to us about negotiating skills, not necessarily commercial leasing, but generally, like Kelsey mentioned, if you realize that you're renting a really small space, you're really only getting kind of a few years at a time, you have fairly low negotiating level, or negotiating power. You have to really prioritize which items you really want with the client, and it also depends on negotiating style. I mean, you're going to talk to a range of different kinds of attorneys on the landlord side. A lot of them are from the big institutional landlords there on retainer, and so they kind of do this like like a mill, and they're going to really talk to you in like formulaic language, and they're not going to want to deviate from their form leases or form riders too much generally. You may, on the other hand, get some smaller landlords, maybe even some kind of individual landlords who own the property not under any kind of corporate capacity, and they may have a landlord who may be willing, or an attorney who may be willing to take more time with you and kind of craft a better lease through more integrated negotiations. And that's something that we can see when we talk about later on in our monthly meetings.
And also on negotiation, I would note that, from our experience, very often the landlord either doesn't have an attorney or doesn't want to engage their attorney because they don't want to spend the money on a lease negotiation. So it is important for us to kind of have clarity on, is this landlord represented by counsel for this lease? If so, then we can only talk to that attorney. If they worked with an attorney to do their template, but they're not working with them now, then we can have direct communications with the landlord. I would say that a lot of times the relationship, especially if it's like a smaller neighborhood landlord and a smaller neighborhood business, often they've been going back and forth on business terms for a while before they are coming to us. And so, sometimes I think it's helpful that we do the kind of drafting and negotiating and coaching of the small business, and then they bring it to the landlord so that they can keep that relationship going. And then also it enables us and our client to do kind of good cop, bad cop negotiating. So the tenant can be like, my attorney's just saying I can't sign this, as is, it's really important, but I really want the space. So to use that dynamic of us and the tenant, and then depending on the tenant and the landlord, sometimes it'll be appropriate for us to step in and directly negotiate with the landlord or its attorney. I do think that it's still important to be mindful of that relationship, and of course to not kind of start negotiating and forget that you have a client, right? Yeah, so, we're not agreeing to business terms without going back to the client and having them. So, but I would say in most instances, I've got to say, in the neighborhoods that our clients usually base, our clients are the ones who are fronting on negotiations, and we're kind of doing a little bit of Cyrano. So we're kind of in the background being like, okay, give them this, these are the key points. If they say this, this is plan B. If they say this, is plan C. But you don't have to agree to anything, right? And then kind of debriefing quickly afterwards. So I do think that a lot of the negotiation, I think it's great if we think about training for us on negotiating skills, but it's also about us training our clients on negotiating skills.
Absolutely.
Yeah, I think that piece is so important because oftentimes if we're good and we're used to negotiating directly with other attorneys, but then there's a middleman. If you haven't trained that middleman out, because even good cop, bad cop can go wrong, right? Because I've seen someone play good cop and say, well, I think what you're saying is a little reasonable, but I'm an attorney. And that's not going to work either, because then you're delaying something when inevitably you are in agreement. So there's a balance in making sure that they understand even when you play good cop. We're not talking about, but you have to actually advocate for yourself and know how to say, this is what I really care about, this is what's important, and make sure that we're training our clients and whoever is representing them, their own advocates and speak like business people, where they're speaking to landlords, because if their approach is to be meek and to play dumb, that's not in their best interest for a long-term relationship either. So.
And this kind of advocacy, this kind of representation definitely counts as an outcome, or you're right, as a legal representation under this program. So that's definitely, we should keep that in our repertoire. If this situation is normally flipped the other way around, to the extent that attorney representation is lopsided for small businesses, it's usually the landlord as an attorney dealing with in pro se small business. And so this may be kind of a novel situation, and in the situation that Jesse mentioned, where the landlord and tenant may have some kind of pre-existing relationship, or they may have had already some kind of negotiations and rapport as between them, we may not want to scare away the landlord or scare it into attorney negotiation at that point. And that's a very good point, to kind of keep the case moving along smoothly, as long as you're confident that the client can advocate for themselves when it comes time for them to communicate directly with the landlord on specific issues. But when they come to you, I've kind of broken it down into 3 different circumstances and the kind of documents that you will normally see. So if the tenant comes to you with a new lease, they've gone and already seen a space with a broker, they've gone down the street and seen a sign for a for sale sign, they may have contacted the landlord and gone and gotten a tour of the space and maybe gotten some preliminary cost estimates from a contractor to come in and fix up the space for them. They may come to you seeking a new lease, and typically the broker will make them sign a term sheet. So that term sheet will be only the very basic points of the lease to be drafted. So things like the exact space that's to be leased, the parties that are going to be leased, the term, at least the initial term of the lease, and the rent. Those are usually the things that will go into the term sheet. It's not a binding contract on its own. It's just points that the landlord and the tenant have already agreed upon in order to, as a jumping off point for you to go ahead and start negotiating and drafting the contract. They're not, at the same time, they're not set in stone. So if there's some other unforeseen circumstance, if you realize there's something latently wrong with the space later on, you may be able to come back and try to renegotiate some of the issues in the term sheet, or some of the points in the term sheet. Maybe less often you'll see an LOI, a letter of intent, which is basically a more detailed term sheet where the landlord and the tenant go ahead and they pre-negotiate a lot more of the terms. It looks a lot more like an agreement. It looks a lot more like a lease. Questionable whether or not it actually is a lease, because typically one or both parties will actually sign the LOI, although most courts have determined that it's just an agreement to agree, so it's not an actual binding lease in its own. It's just an agreement to enter into a lease based upon those terms or something near those terms later on. If a tenant comes to you seeking a renewal, or they have a dispute regarding a current lease, what they bring to you, or what they should bring to you, what you'll want to see are the current lease that's in effect, any riders that are in effect, any renewals that are in effect, and any amendments that are in effect, as well as potentially any other communications that they've had with the landlord, any other drafts of any of those documents that they've had floating around back and forth, anything else that they may find relevant for you to review. And then you will probably also see clients who have no lease or have an oral lease only, and they want to get a written lease from their landlord. Because typically if you have an oral lease, or if you have no lease, if you're a holdover tenant, if your written lease expired and your landlord didn't give you a renewal lease, you're there as a month-to-month tenant. And that's pretty much at will. At any point, either the tenant could leave on 30 days notice, or the landlord could serve a 30-day notice to vacate and start eviction proceedings if the tenant doesn't vacate within 30 days. So there's very few protections for a tenant with no lease or a lease. And in those cases, you'll just want whatever documentation you can possibly get. Communications between the landlord and tenant, any kind of invoices that the landlord used to send to this tenant to show what kind of rent they were paying, proofs of payment of the rent. You just want to get an overall picture of the relationship between the two parties to kind of ground yourself in where to start your negotiation from there. So moving on to the standard form of a store lease. So from here on, I'm going to be referring to the paragraph number. Numerically, we're going to be going sequentially in the lease. And again, this is just for reference. You'll be seeing this document a lot, but I don't necessarily advocate any particular paragraph wholesale in this lease, because typically it is modified by a landlord rider that you'll get. So backing up, so you get your client, you sign them up, they're eligible, they want a new lease. You'll reach out to the landlord's attorney, or they'll already know that you're the attorney assigned or representing the tenant. And what you'll usually get is a marked up version of this revenue form lease together with a landlord's rider that could be simple, could be fairly extensive, modifying or adding lease terms to the revenue form lease. And so we had initially, when we were talking about creating this training, we were talking about creating a model tenant rider of provisions that we think would benefit the tenant. But in thinking more about the process of how these leases work, I think more often than not, we're going to get, at the beginning, we're going to get a landlord's form lease and the landlord's rider. And adding another document to the mix is just going to really, I think, muck it up. Landlords are, again, this is kind of current customary practice, but landlords expect that their documents are going to be used as a jumping off point. So typically the way that the negotiation works is that the tenant or the tenant's attorney gets the draft documents from the landlord in a Word or searchable or modifiable form, and then you just go through track changes for your proposed edits in your negotiations. Once you go back and forth once or twice, I will typically pick up the phone and actually engage the attorney or set up a telephone conference to go through the most important remaining points of contention and see if you can kind of nail those down and smooth them out. Of course, after talking to your client about all of the remaining points of contention and ranking them, which one is most important to them and which one they can maybe get away with, just leaving as the attorney wanted. So that kind of lays out the use of the standard form lease and when you're going to see it. So starting at the very top in the preamble, the most important items are going to be the owner and the tenant, so the parties. The owner, what you'll want to do is to confirm that it's the deed owner. You want to make sure that the landlord who's giving the lease to the tenant is the actual owner of the physical real property where the premises sits. To do that, you can use one of two websites. The first one is the General City Map website. The second one is directly Acris, where you can see all of the documents that are recorded as against real property. The first one pulls information and documents from a number of different websites, and so typically we'll probably want to use that one. Well, I'm not completely as familiar with it as some of you might be, because I typically use the individual websites like Acris and the real estate tax bill website individually. So when you click on the website, you can just search for any location within New York City. So for example, we're sitting at 619 Thorpe Avenue, Brooklyn, New York. It'll show you where it is. It'll show you the entire block and lot where the property sits. And then here it'll give you a basic overview of all of the pertinent information. So you'll see that the address, 619 Thorpe Avenue, is owned by Forest Enterprise, Inc. If this is the space that your tenant wants to lease, this should be the entity that appears in the owner space in the preamble of the lease. And then going down later on, you'll see land use and zoning that will be relevant later on. You'll see ECB violations that'll be relevant later on. And there's a way to get the deed. If you want to absolutely double check who's the owner, you can go to tax and property records. You go to tax and property records. This goes directly to the Acris page for the property. Just search for the deed, and you can see that in 2012, the New York State Urban Development Corporation transferred the property to Boras Enterprise, Inc. That's the last deed on record. So you've done that. You've confirmed who the owner is through a variety of searches on the public records. Who is the tenant? Many times the tenant will form a single purpose entity to sign or hold the lease, or you'll counsel the tenant to do so. It's not an option for everybody, especially really small tenants. There's some financial and reporting burdens simply in incorporating or in keeping up, filing tax returns and things like that not every small business wants to or is able to engage in. If they don't do that, or if they choose not to, or if they're just simply unable to, we'll just need to counsel them that signing as the individual sole proprietor or signing as an individual of the lease makes you personally liable for all of the obligations, monetary and non-monetary, under the lease for the duration of the lease. And if the tenant does decide to form a single purpose entity, for example, they incorporate a business simply to sign and hold the lease, the landlord will probably ask for a personal guarantee of somebody who is creditworthy in order to guarantee the corporate tenant's obligations under the lease, because of course corporate tenant has limited liability. And we'll talk about the personal guarantee a little bit later.
For the entity formation, has Walls recommended generally LLCs or BCLs?
We don't do single purpose entities generally for leases. Well, we mean for when we're incorporating just generally, just highly depends on the business and business owners.
And do you guys think that you'll have the in-house capacity to do entity formations for clients that need entities formed, or is that?
No, I think that, not through Balls probably, because I think the timeline would not make sense, because we would still have to place all those out with pro bono, and then that could take 6 weeks, and then that's just not a timeline that works for a lot of new leaseholders. But I think we should talk about whether that's something that we could expect staff attorneys to be willing to do. But I guess we have to all talk about that.
Yeah, I want to be a part of that conversation because I can say that when you get into the weeds of starting entity formation with these organizations, probably what you're alluding to is it always sounds simple and we're just going to do this and hope the lease, but there's more people involved in ownership, and it gets, once you get to the point of ownership and membership, you have to specify what the percentage is, and that's when issues and things that people were ignoring initially start to come out.
Yeah.
So, yeah, it's never as simple as it seems, because all of a sudden you say, what percentage do you own? We must identify that in this contract, and suddenly they're like, well, there is Bob, and you're like, okay, well, Bob needs to show up. Right?
Yeah. I think that if the client's okay with waiting, then we could refer them through Balls to get their performance, the entity. We could also talk, Balls separately also does some clinics, and we could do, quarterly clinics and have like a 1-hour session where you sit down and decide which entity to be and just kind of give the client advice on what that process would look like if they did it themselves. Not ideal, but I don't think that we could handle necessarily all of the entity formation for all of the leases for this program in-house, or definitely not in-house.
Yeah, I think it's even if it's a BCL or an LLC, especially if it's an LLC, you've got the publication requirement, it's costly and time consuming, so it screws up the timing of like a fast lease negotiation.
Yeah.
Business corporations, easier and cheaper, but most people don't actually want business corporations anymore. So I think we should think about maybe Simpson or some other like folks that like talking about like, would you guys be ready to have kind of like a feeder for fast entity formations, so they have that capacity to take that on. And if not a referral, if we don't have the capacity to do it, then are we going to be saying we need to find a private attorney to do this? And we could be negotiating the lease on a parallel track, but we actually don't want to sign the lease until that entity is formed.
Yeah.
That could be an open issue.
Or
It's not.
to assign, like you could sign it in a personal capacity with a provision that it can be assigned without mental consent to the entity once formed.
It's not uncommon that the identity of the tenant is an open question until the very end. And at that point, if it isn't a corporation, then you'll just draft up a personal guarantee.
Yeah, and we could probably do it. If we did a parallel, then we could probably place those out with pro bono to do the entity formation. As of right now, there's a lot of demand for it, and I don't have any problem placing those matters quickly.
Okay.
When you do that, do they do governance as well, or just?
We do governance as well.
And that's where, and also becomes the issue with the BCL, because there are some governance things that you must do, and that's kind of the attraction of the LLC for people who are used to this, is that all goes away largely, whereas when you form a BCL, you must follow certain rules, and you can inadvertently cause actions that you've been taking all along to actually not to be void, to be simply because you're not familiar with the statutory governance process. So.
We're at 12:30.
Okay. Yeah.
So it's
Let me just get through. Yeah, let me just get through the next slide, and then we will talk about rent onward next time, after the break. So the next section is the premises, where after you identify who the owner, landlord, and the tenant are, there's a portion talking about in the building known as, in the borough of, in the city of New York. That is where you're going to try to get as detailed a description of the premises as possible. This we'll talk about a little bit later on when we have a litigation primer on December 5th, but more often than not, this becomes a very thorny issue for service or for jurisdictional purposes if and when there is a legal dispute that goes into court. So it's very important to get a very specific description of the premises, only the premises that the tenant is taking. Make sure that it's not over or under inclusive. For example, often you'll have in a ground floor complex, you'll have multiple stores side by side that share one mailing address or one street number, and so it's very important to differentiate between store number 1 and store number 2. Ideally, if you get a shaded diagram of the space, either from the landlord should have one, but if it could be even just kind of drawn out is better than nothing. If you can't actually get to the premises, at the very least, I, as the attorney, usually just go and research it on Google Maps and see what it looks like and make sure that the description matches what actually physically is located there. And then also keep in mind whether the tenant has the right to use any other space, for example, storage elsewhere in the building, any part of the basement or any part of the roof. To the extent that it is set forth here in this premises provision in the preamble, it should be qualified that the tenant can only use it for certain purposes, or that it's still a part of the kind of common area of the building, because as we'll get to later on, the square footage has to do with, and many times, the calculation of the rent. I prefer to use terms like entire store rather than entire floor. So if you're talking about 619 Thrope Avenue, the corner store, I would say the entire corner store rather than the entire floor. That kind of encompasses just the store space rather than the floor, where you may include some hallways, passageways, stairways, elevators, things that you don't want the tenant to be responsible for or paying rent for. And then square footage of the space. If the landlord wants the square footage to appear here in the premises description, that's something that I would counsel the client to absolutely get verified. Even if they can individually themselves go on an inspection and kind of measure it out and see whether it kind of pans out. Ideally, if they're doing construction, if they're planning on doing construction or any kind of build out, if they can have a contractor come in and do a very simple space evaluation and make sure that the square footage of the actual usable space that they're renting from the tenant, from the landlord, matches what's set forth in the lease. I would counsel them to do that, because as we're going to see, the base rent often is a calculation based upon the square footage that the tenant is leasing, as well as the renewal rental that's based upon a fair market value estimation of what the square footage value of the space is going to be at the end of the lease term.
And also utilities are often allocated to square footage, so it's also like the additional things that get added to rent often are tied to square footage.
Yeah. So I think we can stop there. That might be a good stopping point, and we'll continue in 12:34. Anyone continue at around 12:50?
Yeah, 12:50, so that gives everybody 15 minutes to run out and get food. So we have a microwave and a toaster oven if you brought food.